Hello, good morning, good afternoon, or good evening, everyone. I am Patrick House. Welcome to this webinar on the specifics of online brand protection in Turkey. We are together for an hour, and I'm going to be introducing yourself to the actual presenters that we have invited today. So I'm Patrick House. I'm the regional director at CSC, based in Paris. Together with me today, we have Mert Saka. Mert Saka has over 10 years of experience in the domain name industry. He's a strategic partner at ICANN, managing relationship with the contracted parties across Europe, the Middle East, Africa as well, leveraging his in-depth understanding of the complex domain name ecosystem. In his role as a GDD, so Global Domain Division Account Senior Manager, Mert is a GTLD expert with a deep knowledge of domain name policies and processes, committed to ICANN's mission of ensuring the security, stability, and resilience of the global internet. He holds multiple certifications in data science, statistics, programming, which he uses to enhance ICANN's data-driven efforts. I'm welcoming today as well Güldeniz. Güldeniz is a partner at Gün Partners, specializing in intellectual property law as a lawyer and trademark attorney since 2006. Her expertise covers trademarks, design, copyrights, with extensive experience in both contentious and non-contentious matters. She focuses on court actions challenging decision of the Turkish Patent and Trademark Office. Additionally, she serves as a panelist at the Turkish DRS provider. Last but not least, we are welcoming today Mutlu. Mutlu is a partner as well at Gün Partners, specializing in intellectual property law, both as a lawyer and trademark attorney since 2006 as well. Her practice covers trademarks, designs, copyrights, with extensive experiences both contentious and non-contentious matters. She has been involved in numerous IP projects, advising on trademarks, copyrights, design, domain names, and unfair competition. Here, a quick overview of the agenda for today. We're going to get starting now. Mert, for an ICANN update, the floor is yours.
Thank you, Patrick. Hello and welcome, everyone. My name is Mert Saka, and I work for ICANN. Thanks for the great introduction. ICANN is a non-profit organization that coordinates and supports the domain name system around the world. I work at the ICANN's Istanbul office, so I'm probably closer in terms of time zones to you watching this. I mainly work for the Europe, Middle East, and Africa regions, but I also have some other duties covering the worldwide operations at ICANN. My slides today are about the internet's evolving, how the internet is evolving, and how your organization can operate a piece of it. It will be also a quick introduction to what ICANN is and how this whole internet system is working before my colleagues provide in-depth information about the other topics. So next slide, please. The internet is a large network of interconnected networks. Today, more than 5.4 billion people are online every day. And if you think of how many devices each person has today in general, every single one of those devices has an internet protocol address, also known as an IP address, which is a long series of numbers. Next slide, please. An IP address is like a postal address. It allows us to send messages, share videos, and exchange any other type of data packets between different devices, as long as they are connected to the internet, of course. But a long series of numbers can be difficult to remember. Therefore, the domain name system, or DNS for short, allows us to enter a domain name instead of an IP address. This can be a website, email address, or anything else. For instance, when you need to type www.icann.org into a browser to reach our website, instead you don't have to use an IP address for that. It's much easier with the domain name. We call all of these IP addresses, IP numbers, addresses, domain names, unique identifiers, because they help to identify each device individually on the internet. To summarize what ICANN does in this workflow, we help to coordinate and support these unique identifiers across the world. Next slide, please. A domain name is also called a URL, or sometimes a website address. In a domain name, the top-level domain, or TLD for short, appears after the second dot at the rightmost side of the domain name. For example, the domain name ICANN.org, org is the TLD. You probably are seeing many different TLDs in the wild these days, other than the ones you're used to. Before I explain why, let me also talk about one type of TLD that only uses 2 letters, the CCTLD, or country code top-level domains. My presentation will not include them, and I'm sure you heard about them, .tr, for example, for Türkiye, and you'll hear more about it in later presentations. My presentation will focus on TLDs that are not CCTLDs. Now, let me continue and explain why you see many different TLDs in the wild. Next slide, please. You may have come across TLDs that are longer than 3 letters, or written using different alphabets or scripts, like Arabic, Chinese, Japanese, or others. The DNS started with just 7 general-purpose top-level domains, including .org, .com, .net. There were several added later, but the number of TLDs did not grow that much until ICANN launched its new gTLD program in 2012. This program resulted in the largest expansion of the DNS. It introduced generic top-level domains, short and long TLDs, and TLDs in different scripts like those you see in here. Next slide, please. So today, there are more than 1,200 top-level domains. The DNS was created using English as the operational language because its founders generally spoke English. Speaking of the founders, at this point, you may have questions like, what type of organization is ICANN, or who authorized ICANN to do all of these? Answering these questions would take much longer than the time I'm given here, so I suggest visiting our website to learn more about ICANN and its history. But to explain ICANN's structure in a nutshell, ICANN is a non-profit organization and has a community of thousands of individuals, governments, intergovernmental organizations, non-governmental organizations, as well as non-profits and corporations and so on. ICANN's structure and its unique multi-stakeholder model is very interesting, especially for legal and legislative professionals. So I strongly encourage that you visit our website. In the next slides, I will talk more about the next steps, and after this expansion had happened later in the later years after 2012. So the expansion of the DNS is an initiative that ICANN is implementing at the recommendation of its community. It is a mandate to assure that expansion ensures security, stability, and global interoperability of the Internet. For the first time in more than a decade, businesses, communities, governments, and other organizations have the opportunity to apply for new gTLD tailored to fit their own interests of their organization, of their business, customers, community, and cultures. Next slide, please. New gTLDs are intended to provide greater consumer choice. For brands and businesses, it can create awareness and increase the trust in the brand itself, or serve many other purposes as it does to others to help industries, tools, locations, languages, and other identities. Some of those you can see on the slide, and there's many more. Next slide, please. This slide explains the gTLDs in a broader perspective for various communities, organizations, governments, and so on. But at this session, I will focus on the use case for brands. For businesses, a gTLD may be seen as a branding opportunity, but the use cases are almost limitless, allowing to develop a unique label on the Internet. Next slide, please. So a business managing a gTLD can vet its branches, like franchisees, stores, and others that need a domain name. to have their own identity or website or email addresses on the internet. Similarly, it maintains trust in the business to protect the brand associated with the GTLD. For example, if the messages come from an email address ending with your brand, it creates trust that the email comes from your business. Similarly, those visiting your website know they are at the right place more easily because they can see the brand at the end of the website address. And there are other perspectives that are not external but internal, such as the technical ones or your company internet, which may be subject of a whole other webinar. In short, if implemented well, a GTLD can be a source of significant help for the brands. Next slide, please. As an organization, there may be various objectives to apply for a GTLD, but there are technical and financial considerations as well. By approving a GTLD application, ICANN makes sure these considerations are also considered. In other words, by having someone operate a TLD, ICANN trusts that organization to operate a piece of the internet. Therefore, the applications for GTLDs in the next round will be evaluated in detail. If your application gets approved, your organization decides the requirements to apply for registering a domain name under that GTLD. Next slide, please. So, when is this next round that will allow applications to begin? Next slide, please. Here's a timeline for the important dates that you may want to take note of. ICANN is currently running an applicant support program, or ASP, which is a program offering a range of financial and non-financial assistance to help eligible applicants apply for a GTLD. I will not go into the details of this program as well, which started in 19th of November. It is very detailed, but you will be able to find more information in the links that I will provide at the end of my presentation. ICANN also has been working on an applicant guidebook, which will guide all the applicants of the next round through the details of the application process. In May this year, we expect to put out the guidebook to collect comments publicly and release the ICANN board approved version before the end of this year. And finally, in April 2026, not this year, but next year, we expect to open the program for receiving applications and keep it open for around 12 to 15 weeks. If you're thinking about applying for a GTLD, then I suggest starting to think how your organization may benefit from operating one and having discussions with your colleagues, because these brainstorming and conversations may take time. Starting to prepare for an application now would be a good idea. Next slide, please. And here are the links that I promised. The GTLD program Next Round website offers the most up-to-date information about the next round of applications for the new GTLDs. There you'll find links to resources, including news and announcements, FAQs, the handbooks and applicant guidebook, and many more. I suggest checking our website and subscribe to ICANN News to receive the latest news about the next round of the program, which will be delivered to your inbox directly. Next slide, please. So that wraps up my presentation. Thank you, and I would be happy to answer any questions. Back to you, Patrick.
Thank you very much, Mert, for this for the presentation on the latest update of ICANN. I'm going to be moving forward in the agenda for today. As you can see, the landscape, the domain landscape has been changing, evolving, growing quite a lot over the last decade with the new GTLD program coming up. And this has been created quite a lot of risks to organizations, to brands who are in a situation where they need to be able to defend themselves. So it's all about, putting in place proper strategies in order to protect your brand online. And I wanted to start this presentation by showing you an example of, real life example, how companies have been in some cases suffering from not having a proper domain protection or online brand protection strategy. And here is an example of a very big French organization called Vinci. Vinci is a leader in the construction and energy. They are present in over 100 countries in the world, and they have more than 300,000 employees globally. It's a company which is listed as well at the Paris Stock Exchange. So what happened to Vinci that day of 2016 when basically their share at the Paris Stock Exchange dropped by nearly 20% within a few minutes. Basically, what happened to this company, they have a core domain, which is Vinci.com. And as you know, with this first come, first serve rule, anyone can, register any other domain which is available. So if your core domain is Vinci.com, anyone can start to register domain like VinciGlobal.com, VinciGroups.com, or even Vinci.group. And this is exactly what happened to Vinci in 2016 when a bad actor decided to register a deceptive domain and start to send fake emails to Bloomberg, which is a financial communication agency, pretending to be the CFO of Vinci, so the chief financial officer, and alerting the entire planet and the financial markets, of course, on profit warning, which is basically the worst case scenario for a company which is listed at the stock exchange. So there are two angles, when it comes to securing your online presence. You need to first secure your own digital assets, your own domains that you have under your management, but you also need to be able to detect what bad actors are doing out there in the wild using your intellectual property and your trademarks. The difficulty about that, again, is that nothing is basically behind your firewall and protected behind your devices, and everything which is linked to your online presence is out there in the wild. You need to be using different providers to be able to run a website and to make sure that users are able to reach your website. You have ISPs, you have hosts, you have registrars, and so on, and they are not basically behind your firewall. This is what we call the external attack surface, and that's basically where 80% of the breaches are coming from. So as I was mentioning, this first come, first serve rule, which is one of the basics of the domain systems, create a lot of risks on brand, and this is exactly why companies and brands need to have a proper strategy in place in order to be secure online. So when we think about having a proper online brand protection strategy, there are different ways, to tackle this problematic. One of them is to try to organize basically the way you are facing requests from your counterparts when it comes to domain. And when you are managing a domain portfolio, every day or every week, you are getting many requests from your colleagues or from third parties informing you about specific stuff regarding domains. So you can have a subsidiary willing to register some domains. You can be informed by people about domains being registered by third party which are infringing your brand. You're facing basically many different situations. So in order to get organized and have a proper strategy around that, there are different ways to do it. One of them is to try to organize all these different situations into buckets, answering, for example, two very easy questions. One of them is the domain that I'm facing a strategic domain for me, an important domain for me, a domain which should be in my portfolio? The second question you may want to ask yourself facing each situation is whether you already own this domain, or is this a domain which is owned by a third party? And depending on whether you're going to be answering yes or no to any of these questions, you can basically group all these situations into different buckets. I chose to highlight 4 of them, which are the main situations. So for example, if a domain is strategic for you and you already own this domain, you need to make sure you consolidate these domains or you register the domain in case they are still available. Within this group A of domains, which is your core domain portfolio, there's going to be some which are considered as vital for your organization, and that's typically the ones where you're going to apply some security features like registry lock, DNSSEC, and all these kind of things. You may see some other situation where that's the group B, where a domain is like strategic or important for you, but it's not owned by yourself. And in this case, we are speaking about infringement, and that's when you need to have proper enforcement actions in place, and that's something we're going to be covering a bit later in the webinar today. You may see some domains which are not strategic, not important for you, but you own them, they are in your portfolio. These are domains that you may want to lapse or divest at some point. And last but not least, Group D, you are facing here domains which are not strategic or important for you, and they are not also owned by yourself. So all this is covered by what we call domain threat intelligence. This is the fact that you're going to be monitoring what's happening in terms of domain registration or domain lapses in order to see which are the domains used by third parties in order to attack your brand. So that's typically the kind of situation or strategy that you may want to put in place in order to organize your domain management. And that's typically something that you would put all together in a written format in a domain policy, for example. So getting a little bit closer to what's happening in Turkey with the specifics of online brand protection, and I highlighted here a few examples. There are many different changes happening all the time within the domain space. Mert gave us a great introduction about what's going on with the new GTLDs. Here on the slide, you have another couple of examples about what's happening within the CCTLD space, the country code space, where all the time you have, constant evolution, whether this is in Venezuela, Lebanon, Iraq, and all these kind of areas or geographical CCTLDs. If we look more specifically about what's going on within the .tr space, we ended up in a situation where we've been having a liberalization of the extension .com.tr, where the local presence in order to register and maintain a domain was not required any longer. And as well, we got the launch of the TLD .tr with a priority phase for .com.tr domain owners, which is now completed, followed by a phase called general availability, where basically anyone can register this new .tr domain on the first come, first served basis. So the recommendation, again, when it comes to protecting your brand under the .com.tr or .tr domain, is that whether if there are still existing opportunities, it's still time, to consider registering and securing your domains within the .tr space. So as I was mentioning, lots of risks, which creates many different infringing situations. And I'm going to hand over to Güldeniz now, who's going to be deep diving into all these aspects.
Thank you, Patrick. Hello, everyone. Thank you for being here today. And Patrick, thank you for the introduction at the beginning. My name is Güldeniz Doğan Alkan, and today I will present the alternative dispute resolution system for TR domain disputes. I will first provide an overview of the regulatory framework, dispute resolution mechanism, and mention a few key points on precedents rendered under the new system. Next slide, please. Next one. On September 14, 2022, the management of TR domain names officially shifted from NIC-TR to TRABIS, TR Network Information System, under a new regulation. The regulation introduces two types of domain name allocation, which is documented or undocumented. Undocumented domains are assigned on a first-come, first-served basis. Previously, securing a TR domain required proof of an existing right, such as a trademark or a trade name. But with this new regulation, there's a big shift from past practices, making domain allocation more flexible and easy. And as of September 14, 2023, 1 year later, in addition to well-known domains like COM.TR or org.tr, it is now possible to register shorter domains in the .tr format as well. Next slide, please. For domain names obtained before and which are not renewed after September 14, 2022, disputes are still handled by national courts. But on the other hand, for domain names which are obtained after this date or renewed after September 14, 2022, disputes are resolved through DRS providers, which are accredited by TRABIS. This marks a big shift towards a specialized alternative dispute resolution process, which is very good. There are currently 3 DRS providers in Turkey, which are accredited by TRABIS. Those are İstak, Tobium, and UCM.TR. Next slide, please. When we look at the legal framework, we see that it is established under Article 25 of the regulation. A domain name can be transferred to the complainant or cancelled if the following 3 conditions are met. The domain name is identical or similar to a trademark, trade name, business name, or other identifying mark of the complainant. The domain name owner has no legal right or connection to the domain name, and the domain name was allocated or used in bad faith. As you can see, unlike UDRP rules, the first condition takes into account not just the complainant's trademark, but also other prior rights, such as a trade name, business name, or any other identifying mark. I consider this issue as significant because in some cases, even if the right holders have not registered a trademark yet, they still can apply or file a complaint regarding the domain names bearing their other marks used in commercial life. The second condition remains the same as the UDRP rules, but the third condition also includes a difference and takes a different approach by using the word or instead of the word and when assessing the allocation and use of the domain. This means that under Turkish law, it is enough to prove that the domain was either allocated or is used in bad faith, so there is no need to show both occurred together. Next slide, please. After the summary of legislation and the overview of the system, I would like to look at the precedents so far for each condition. For the first condition, decisions from DRS providers have shown a few key trends. If a trademark is not registered, the complainant must provide proof of genuine use. In some cases, simply having a trademark application is not enough to establish prior rights. Trade names and business names are taken into consideration when evaluating the first condition. And beyond that, names used in artistic activities like pseudonyms or nicknames, as well as previously registered domain names, are also recognized as other identifying marks. As parallel with UDRP decisions, even descriptive or non-distinctive trademarks of the complainant are taken into account as a factor in the examination of the first condition. And as can be understood from these points, I can say that there is a broad perspective in the examination of the first condition. Next slide, please. In terms of the interpretation of the second condition, there does not appear to be any difference from UDRP decisions. In cases where the complainant can prove at first glance that the domain name owner does not have a legitimate right, the burden of proof for the second condition falls on the domain owner, and we see that in most of the cases, panelists accept the same. Next slide. As mentioned earlier, according to the legislation, bad faith can be either in registration or in use, and we do not seek for both in TR extended domain name disputes. According to precedents similar to the UDRP decisions, we see that Some indicators of bad faith include the domain owner offering to transfer the domain to the complainant, the domain being registered after the first come, first served rule came into effect, providing false or incomplete information during registration, and the pattern of registering multiple domain names in bad faith. Next slide, please. In this slide, I wanted to summarize the timeline of the procedures for DRS disputes. It usually takes 30 to 45 days for the decision to be rendered by the DRS provider after the filing of the complaint. This depends on possible extensions, which can be obtained by the domain name owner. It's an extension of 10 days for submitting the replies, and by the panelist, which is an extension of 5 days. So far, approximately 600 disputes have been received by all 3 DRS providers in Turkey. We know that very few of these decisions were challenged by the parties before national courts, which is very good and shows that the decisions of the DRS providers are accepted by the parties. I would also like to note that it is possible for the parties to apply to national courts directly rather than to DRS providers, but we experienced that usually parties prefer to apply to DRS providers because it is time and cost effective. I also want to note that the complainant is not able to apply to another DRS provider regarding the same domain name until the first complaint is finalized. When this is finalized, there is no obstacle for the complainant to apply to another DRS provider or to the same DRS provider once again. And there is no limit of the number of times the complainant can file a complaint before DRS providers. And although theoretically it is unlikely that the decision will change unless there's a concrete new evidence or development in the file, there is no obstacle for the complainants to reapply for unlimited times to DRS providers regarding the same domain, because there's no provisions, no restrictive provisions in the regulation in that sense. So this is why all I wanted to explain regarding DRS provider system in Turkey. Thank you for your attention, and I'll leave the floor to Mutlu. Thank you.
Thank you, Güldeniz. Hello, everyone. It's great to be here today with my colleagues, and thank you for joining us. As one of the fastest growing digital markets, Turkey presents exciting opportunities for businesses and innovators. However, this rapid expansion also brings significant IP challenges, ranging from counterfeiting and copyright infringement to domain name abuse. As digital platforms continue to expand, protecting IP rights has become more complex and more important than ever. In my session, I will share insights into the current landscape of online IP enforcement in Turkey and discuss effective takedown strategies for right holders. Next slide, please. First, I would like to highlight that Turkey's IP laws are aligned with IP regulations and international treaties such as the TRIPS agreement and WIPO standards. Turkish courts have become more responsive in addressing IP violations online, regularly granting injunctions and enforcing content removals. The Information and Communication Technologies Authority, BTK, also plays a key role in blocking access to infringing content when necessary. Despite these advancements, right holders still face challenges such as jurisdictional issues, hidden infringers, and ever-changing digital infringement tactics. However, there are still several legal actions available, such as civil and criminal actions, preliminary injunctions, and notice and takedown procedures. Next slide, please. When we look at legal actions against online infringement, Turkey's IP code outlines the rules for trademarks and other industrial rights such as designs, geographical indications, and patents. Copyrights, on the other hand, are governed by the copyright law, which has almost similar provisions. Under Article 7 of the IP Code, registered trademark owners have the right to prevent unauthorized use of identical or similar marks, including in online environments. This protection also extends to domain names, redirect codes, and keywords that may cause confusion. In these cases, right holders can file a civil court action to determine the infringement, stop the violation, and seek compensation. They can also request a preliminary injunction, either separately or as part of the main case. In practice, if the infringement is clear, courts often grant preliminary injunctions to block access to infringing websites until a final decision is made. However, it's important to note that these decisions only apply within Turkey, so the content could still be accessible from other countries. For trademark infringements, criminal complaints can be filed too, but this option isn't available for design and patent violations under IP law. In the trademark cases, those involved in producing, selling, importing, or transporting counterfeit goods can face 1 to 3 years of imprisonment and a judicial fine. When it comes to online cases, identifying the source of counterfeit goods can be challenging, as sellers often hide their identities. This is why detailed investigations are very important. For example, before taking any action, we conduct on-site investigations and try to find source. And if we are able to identify the source, a criminal complaint can lead to a search and seizure warrant, followed by raids, which can allow us to confiscate the counterfeit goods. If the source cannot be found, the complaint might only result in access blocking. Next slide, please. When it comes to the notice and takedown, online platforms or service providers are generally not responsible for illegal content posted by users. However, if they receive a valid notice from the rights holder and fail to remove the infringing content, then they can be liable. Next slide, please. We have also specific provisions regarding notice and takedown procedures. Under the e-commerce law, platforms are required to remove infringing content within 48 hours of receiving a complaint supported by evidence, like trademark registration certificate. If they fail to comply, they can face administrative fines. However, last year an annulment application was filed to challenge these provisions before the Council of State and the Constitutional Court. The Council of State has already suspended key parts of the regulation, but since the cases are still pending, the provisions remain in effect for now. So we can still apply the e-commerce law. Next slide, please. For copyright infringement, there is a separate takedown mechanism as well under the additional Article 4 of the copyright law. The rights holder first needs to notify the content provider and give them 3 days to stop the copyright infringement. If the content is not removed, the rights holder can then apply to the public prosecutor, who can order the service provider to suspend the service to the infringing provider within another 3 days. But in practice, prosecutors often obtain expert reports, which can take a few weeks. So while this isn't the fastest remedy, it can still be a useful takedown alternative. Next slide, please. To wrap up, effectively combating digital IP infringements requires a multi-layered approach. One of the key strategies is employing platform-specific complaint mechanisms. As we all know, major digital platforms like marketplaces, social media networks, and content sharing websites have their own takedown procedures. Using these mechanisms can lead to faster removals. If the infringer's identity is known, sending a cease and desist letter can also be an effective approach. This can work not only for individuals, but also for e-commerce platforms and social media channels that don't have formal takedown procedures. If such informal measures fail, court-ordered injunctions can be used to block or remove infringing content. Before taking legal action, it's often helpful to conduct a physical investigation to identify the infringer and the source of the goods. And finally, when dealing with unauthorized or fake domain registrations, right holders can take actions through ICANN's UDRP mechanism or local domain name dispute resolution channels, as my colleague Güldeniz explained. Thank you for listening to me. If you have any questions, please feel free to ask.
Thank you very much, Mutlu. This webinar is now over. We wanted to thank you very much for your participation today. I would also like to thank my co-speakers this morning for their great presentation on these specifics of online brand protection in Turkey. And we are very much looking forward to welcoming you to a next webinar with us. Thank you very much. Have a great day.